Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and this is another episode of Ask the Lawyer. Generally, if you're having to apply for workers' compensation, your life is probably already pretty stressful. And then if your request is denied, well, that only adds to the stress. Well, today we're going to try and help with that. We're going to ask the lawyer about what your options are if that happens to you. And here to answer our questions is attorney Sarah Stottlemyer of the Atlanta firm Stottlemyer Associates. Sarah, thank you for making some time for us today. I appreciate it.
Thank you so much for having me.
So you and I have talked about workers' compensation before, but we didn't really talk about denials. Denials happen, right? That is a thing?
They do happen pretty frequently in cases. In Georgia, I think it really depends on what state you're in. In Georgia, there are not a lot of repercussions per se for denying a claim. So sometimes an insurance company will just not file the required forms, which would be a WC3 controvert of the claim, and they'll just ignore the claim altogether. In other states that are more injured worker friendly, then they can get slapped with civil penalties or attorney's fees. So they're less likely to deny claims in workers' compensation.
So I want to make sure I understand. You said in Georgia, sometimes they don't deny the claim, they just ignore the claim?
They do. When you file a WC3, it immediately sparks a whole other system of forms that they need to do. The injured worker has a variety of other options and rights that they can seek out when an employer insurer have actually denied a claim. Unfortunately, in Georgia, a lot of them just seem to, if a doctor makes a medical treatment recommendation, they just won't comment on it at all. So you will be fighting for weeks to try and get certain treatment to be authorized.
Wow. What are some of the more common reasons you see for denials when there are actual denials?
So there's intoxication defense. That is, if you were intoxicated at the time of the injury. There's a drug defense, very similar to the intoxication defense. Willful misconduct, that is if your employer has told you repeatedly, say, to put on a harness or something like that. If you're on a roof and you ignored them repeatedly, and then you fall off the roof and suffer a work-related injury, that could likely be barred. There is pre-existing claims, where if you had a pre-existing injury prior to this, or pre-existing condition prior to this injury, they might deny the claim for that, or they might just say it's not related at all to the work-related injury. And the example that I could give you would be psych claims, where somebody is requesting treatment for psychological treatment, but they didn't suffer what we would consider to be a injury similar to being involved in a war, PTSD. General psych claims, unless there's an actual physical injury to the person, will 99% of the time be denied.
I've heard of times where it's almost like the initial claim is almost always denied, just rubber stamp denial, hoping that people just go away or don't follow up. Do you see that happening?
I believe that the percentage in Georgia is around 80% of injured workers are not represented by an attorney.
Right.
So adjusters occasionally, now there are really good adjusters out there, but a lot of times adjusters can just deny and ignore and not respond to the injured worker until an attorney gets involved. So that is actually a pretty frequent occurrence.
So if there is a denial, there's an appeals process, correct? Take us through that process.
So you can request a hearing, which is done on a WC14 form with the state board. Then the discovery process would get started. It ends up being approximately 9 months to a year before you get a hearing on your case to actually go forward before the state board, because there's a backlog of cases and they allow a number of continuances before making the employer insurer go forward in order for them to conduct discovery, get medical records, take a deposition, send the injured worker to their doctors to get a medical opinion. So it's not a fast or expeditious process in any way, shape, or form. Then you've got the appellate division, which it's another 3 to 6 months there to appeal it and get a decision from them that generally would be binding.
Wow, so that's a long process.
It's a very long process. And, I think that's the reason why a lot of injured workers that get hurt, they just don't want to deal with workers' comp. They want to get out of the system as fast as possible.
Wow. So the initial claim, I imagine most workers just file that on their own without help from an attorney. Appeals, does the number of people that have an attorney go up when it comes to appeals time? And is that something you would recommend?
So by the time that somebody, even if they request a hearing on their own, most of the time they don't actually request a hearing on their own.
Right.
Once they've been denied a claim, if an adjuster starts messing with their medical treatment or not paying their income benefits in a timely fashion, usually an attorney gets involved and we file the WC-14 for them, and most of the time they're represented.
Okay.
For that actually hearing process. And an appellate division, it's actually rare for an injured worker to go before the appellate division, what we would call pro se, which is without any sort of counsel representing their interests.
If the appeal is denied, is that the end of the road, or is there more you can do?
So you can go up to the Superior Court level and the Court of Appeals and the Supreme Court. The Supreme Court takes, I don't know, probably 1 in 5,000 workers' comp claims,
Oh, wow.
maybe. It could be an exaggeration, but your chances of reaching the Supreme Court, I've never seen it. It's very, very rare. And when I'm speaking about the Supreme Court, I'm talking about the Supreme Court of Georgia, not the Supreme Court of the United
Right.
States. The Court of Appeals takes several cases on per year, but they're generally only dealing with questions of law. Any case that is dealing where the administrative law judge and the appellate division made a decision based on questions of fact, those cases will not go up because it just comes down to a question of law, and then the judges at the higher tribunals can actually differentiate of whether or not they're following the law accurately.
Gotcha. Now, in your experience, is the appeals process, when someone hires an attorney to help them with the appeals process, is the decision often overturned? What percentage would you say comes out in favor of the person who's filed the initial claim?
It's not a regular occurrence that they are overturned. The administrative law judge is in the best position to judge the credibility of the witnesses because the witnesses are not appearing before the appellate division. So they don't know how the injured worker or the employer representative came across in court.
Right.
So they grant great deference to the trial judge in those cases. So yes, you do get them appealed at times by the appellate division, but from what I've seen, the majority of the time they are affirmed by the appellate division from the lower court.
So let's say I make a workers' comp claim, it's denied, I decide I need to file the forms and need to hire an attorney. You told us already it's a very long process, but I assume I need to get an attorney involved as soon as possible. Is there some sort of time frame? Can I wait? Is it possible to wait too long to get that done? How's that work?
I would recommend most people have free consultations. In fact, pretty much every injured worker attorney that I know has free consultations. So I would recommend reaching out to somebody as quickly as possible, lay out the facts of your case and what the insurance adjuster is doing to see if you have a viable claim and to get whatever issue you're having rectified. The sooner you get an attorney on your case, the better, if you need one, due to the fact that we know the doctors, we know the defense attorneys, we know who your judge is going to be. So we can actually help facilitate the process and move along more quickly. But I do think that it's important to at least consult with an attorney as fast as possible.
And I assume it seems like with most things when the government's involved, that there's windows of time that you've got to have certain things done by. Is that correct? Things
Yes,
filed by
absolutely. So you have 30 days to actually notify your employer of an accident.
Right.
When you had an injury, you obviously want to do it as fast as possible. But 30 days is the general rule. In that time period, if you can consult with an attorney so you can start to manage your medical treatment and get with the best doctors, that would be the best case scenario for your case moving forward. A lot of mistakes can be made during the initial stage. For example, you're only granted a one-time change on the panel of physicians if there is a valid panel of physicians posted. So if you select what we call an industrial clinic as your initial doctor to see after you've suffered a work-related injury, and then you change to another orthopedic on the panel without knowing whether that doctor is employer insurer friendly, then it can really mess up your case moving forward because then that avenue for obtaining additional treatment will be gone.
And that's information an attorney who's had experience would know, correct?
Yes, and most injured workers do not know that.
Right, absolutely. Sarah, thank you so much for your time today. I think you've offered a lot of helpful information. I appreciate it.
Thank you so much for having me.
Well, that's going to do it for this episode of Ask the Lawyer. My guest has been attorney Sarah Stottlemyer of the firm Stottlemyer Associates in Atlanta. Please take a second to click on the button at the bottom of the screen so you can subscribe to our YouTube channel and you'll know when we have future episodes of Ask the Lawyer. If you want the best information about workers' compensation, or you're ready to choose a lawyer that lawyers choose, be sure to visit AskTheLawyers.com. I'm Rob Rosenthal for AskTheLawyers.com.